A 38-year-old man stands before a judge, having just pleaded no contest to the aggravated sexual assault of a child. But this is no ordinary plea deal. There is no agreed-upon sentence. Instead, Christopher Davis has thrown himself at the mercy of the court in what's known as an open plea. This means his fate rests entirely in the judge's hands, with a staggering range of punishment from just 5 years to a life sentence in prison. The prosecution is demanding the maximum life. The defense is begging for 20 years. To sway the judge, the defense will call the defendant's own parents to the stand, revealing shocking childhood trauma in a desperate bid for mercy. But the judge has a stunning reveal of her own, one that will dismantle the defense's entire strategy and expose the truly manipulative nature of this crime. Get ready for a tense, emotional, and unpredictable sentencing hearing where one person's decision will determine the rest of a man's life.
All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. Could I have parties announced for the record for the state?
Allie Jackson.
Defense.
Robert Barron's for Mr. Davis.
Suzanne Kramer for Mr. Davis.
And are you Mr. Davis?
Yes, Your Honor.
Counsels, have you received all of the discovery in this case, and did you review that discovery with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Davis, did you review the document entitled True Bill of Indictment with your attorneys? Did you understand it?
Yes, Your Honor.
Counsels, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding on the lesser included offense of sexual assault of a child that was contained within count 1.
Any objection?
No.
All right, Mr. Davis, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right, did you understand the state is proceeding on the lesser included offense of aggravated? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
And able to assist in his defense, and we believe he's competent to enter his plea.
Right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he was sane at the time of the offense? Mr. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly involuntarily waived his right to jury trial. Off the record for a moment. All right, we are back on the record. According to the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the lesser included offense. Punishment is to be open to the court. What that means is that the court can sentence you anywhere from 5 to 99 years or life in prison. Do you understand?
Yes, Your Honor.
And is it your intention for the plea agreement to be that you plea open to the court?
Yes, Your Honor.
Okay. And then there's Chapter 62 compliance, and there's no contact with the complainant, and there's a checked box for no application for community supervision or deferred adjudication. You understand you're not eligible, correct?
Yes, Your Honor.
All right, so you understand that the court will either sentence you from 5 years all the way up to 99 years or life.
Yes, Your Honor.
And that is your understanding of the plea bargain agreement?
Yes, Your Honor.
Defense,
Yes, Judge.
state.
Yes, Judge.
All right, and also I can sentence you up to $10,000 fine. Did you understand that as
Yes,
well?
Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorneys? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsels, have there been any such motions? All right. Then to the lesser included offense, how do you plead?
There were pretrial motions regarding discovery things that you did sign after the state not conferred on them. I think evidentiary motions.
All right. Then to the lesser included offense of aggravated.
With the plea of no contest officially on the record, the proceeding shifts into its most critical phase, the punishment hearing. The legal formalities are over, and now it's all about the motion, persuasion, and mitigation. The defense's goal is to present evidence that might convince the judge to lean towards the lower end of that 5 to 99-year sentencing range. This is where we hear about a defendant's troubled past, their character, and any mitigating factors that could paint them in a more sympathetic light. The defense starts by making two small but significant corrections to the pre-sentencing report, one about the defendant's military discharge and another about the age he was when a traumatic event occurred. Now they're about to call their first witness, the defendant's own mother. Her testimony is designed to do one thing: show the judge that the man standing before her is not just a monster, but a product of his own past trauma.
Sexual assault of a child, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states Exhibit 1 with all attachments. We would also call a witness, Your Honor.
All right. Any objection to the stipulations? All right. I'll allow you to call your witness once I review the stipulations. All right. Mr. Davis, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Well, strike that. There will be some testimony today. You understand? All right, court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense?
For Mr. Davis.
Suzanne Kramer, also for Mr. Davis.
All right, Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection, state?
No, Your Honor.
Defense?
A couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he refers to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right, any witnesses?
Not from the state, Your Honor. We just have argument.
Just Mr. Davis, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right, call your
Let's
first
call
witness.
Edith Davis.
All right, Edith Davis. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you're going to need to keep your voice up so the court reporter can hear. Could you state your name for the record?
Edith Davis.
All right, defense?
All right. And Ms. Davis, are you Christopher's mother?
I am.
All right. And I think you may have heard me state just a minute ago about something that happened to Chris that you said happened at age 2.
Yes, sir.
And can you explain to the judge what happened and how that turned out?
So our babysitter was leaving. We were looking for a new sitter. My husband's getting ready to go to Korea. We found a lady that was in the neighborhood. She had 2 other children that were a little bit older. I had come early one day and found their children throwing rocks down on my.
This is a classic and often powerful defense strategy. Edith Davis, the defendant's mother, just painted a disturbing picture of his childhood, being fed dog biscuits and, most horrifically, being tormented by older children with a vacuum cleaner. The defense wants the judge to see a cycle of abuse, to connect the trauma Christopher Davis experienced as a helpless child to the terrible crime he committed as an adult. The intention is to humanize him, to argue that his actions, while inexcusable, did not happen in a vacuum. They are attempting to plant a seed of doubt about his culpability, not for the crime itself, but for the length of his punishment. This testimony isn't meant to excuse his actions, but to provide a context that might lead the judge toward a more lenient sentence. The key question now is whether the judge will see this as a legitimate mitigating factor or as a desperate, irrelevant plea for sympathy.
My children, Christopher was almost 3, not quite. Then when I got, found out she was giving them dog treats or cookies for their snack. And I had known that both my kids, Kristen was disabled, but Christopher, very active, gotten very, very afraid of when I was cleaning house. I didn't understand why, but when I had talked to my daughter, she told me that the kids would take the vacuum cleaner and suck on Christopher with it and tell him that he was going to suck him up and he would suffer. So when I saw what was going on at the house, I immediately removed him from the house. I found my next door neighbor was going to take care of them for me. So it took a little while to give him a little bit.
The emotional weight in the room just skyrocketed. The defendant's father, Michael Davis, just delivered a gut-wrenching testimony steeped in personal guilt. His raw emotion is palpable as he laments a single decision, not telling the Navy about his son's ADHD. In his mind, that one phone call is the fork in the road that led them all to this courtroom. This is the devastating ripple effect of crime. It doesn't just harm the victim, it shatters families, leaving parents to second-guess every decision they ever made. While the mother's testimony was about the defendant's past trauma, the father's is about his own personal failure and regret. He's not just asking for mercy for his son, he's shouldering a portion of the blame himself. This kind of raw parental guilt is incredibly difficult to listen to and adds another complex emotional layer for the judge to consider before she hands down her sentence.
More calm down, but it was pretty traumatic for them.
And did you have a statement that you wanted to read for the judge?
I do. That's okay.
All right. State, do you have any objection to the reading of the statement, or would y'all?
Statement.
Well, I mean,
I know.
it's a narrative, but if you all want her to read from it, or counsel, if you want me to read it,
I have no objections.
all right, you may proceed. That's okay. If you want to, I can actually read it.
Thank you, Judge.
All right, you're welcome. No problem. Just give me a moment.
The defense rests its case for mitigation with the defendant's own words. Christopher Davis gives a textbook statement of remorse. He offers no excuses, takes full responsibility, and says he'll accept whatever punishment the court deems just. And with that, the gloves come off. The judge lays out the battlefield. The punishment range is 5 years to life. The state immediately asks for the absolute maximum, life in prison. In response, the defense requests 20 years. The gap between those two numbers is colossal, and the judge now holds one man's entire future in her hands. She has heard from his distraught parents about his traumatic past, and she has heard him express his own regret. Now she will hear the legal arguments. But before that, what do you think is a just sentence here? Is life too much? Is 20 years too little? Let us know in the comments below.
All right, any further questions?
Do you have anything else you'd like to tell the judge? Okay, nothing from Ms. Davis.
All right, thank you.
I'm going to
Okay.
call Michael Davis.
All right, Michael Davis. Does anybody have any Kleenex?
I'm trying to get one, Judge. I can't reach.
Okay, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Davis.
All right, defense.
All right, Michael, are you Christopher's father?
Yes, sir.
We've had some conversation about this scenario, and it's my understanding that you feel like maybe you could have done something different and would have avoided all this. Can you explain to the judge what you're feeling?
Yes, ADHD runs in our family. I was never diagnosed, but I've had issues with it my entire life. I'd learned to deal with it. When Christopher finished high school, he quit taking his medication. And when he joined the Navy, if I had called the reservist office and told them that he was ADHD, because I know he didn't tell them, they would either rejected him or kept you know, had him take his medication, his whole life would have been different. One phone call, if I'd made it, wouldn't be here.
This is a fascinating and incredibly risky move by the defense attorney. After the judge explicitly states she won't sentence his client to life, but also won't give him just 20 years, the defense pivots to an argument of sentencing disparity. He's essentially accusing the prosecutor's office of being inconsistent, pointing to a completely different case, one involving the death of a child, where the sentence was only 18 years. This is a Hail Mary legal argument. He's trying to suggest that his client is being unfairly singled out for a harsher punishment compared to other defendants. The judge immediately recognizes this tactic for what it is. Her response is swift and dismissive. She reminds the attorney that every case is unique, and you simply can't compare the sentences unless the facts of the cases are virtually identical. The tension is rising as the defense attorney is about to push back.
So, love my son, I know he did wrong, but that's all I've got, ma'am. I'm sorry.
No, I appreciate you coming in to testify.
I don't have anything further, Judge.
Any other questions?
The judge is putting on a masterclass in courtroom control. The defense attorney continues to push his sentencing disparity argument, bringing up another case where a defendant received only 12 years for a similar charge, but the judge is ready for it. She introduces a legal concept known as on all fours. This is a term lawyers use to describe two cases that are so factually similar, they are practically indistinguishable. She challenges the defense, if you can show me another case that is on all fours with this one, where the state offered a lower sentence, then she'll hear it, because that might suggest unfairness. By doing this, she's not just shutting down his argument, she's daring him to prove it. She knows he can't, because she's about to reveal the one unique, horrific detail of this case that sets it apart from all others. She is laying a verbal trap, and the defense attorney is walking right into it.
Thank you so much.
And Judge, at this point, I just have Mr. Davis.
All right, you want to raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation. There's no rhyme or reason.
And there it is, the bombshell that changes everything. The judge completely dismantles the defense's argument by revealing the sickening, manipulative core of this crime. This wasn't just an assault. It was a sophisticated deception. Christopher Davis allegedly pretended to be a juvenile online to befriend and groom his own stepdaughter. He then manipulated her into sexual acts by fabricating a story that her new friend's life was in danger if she didn't comply. This detail is crucial. It elevates the crime from a straightforward assault to a calculated psychological torment. By revealing this, the judge isn't just justifying her sentencing philosophy. She's showing everyone in the courtroom, especially the defense attorney, exactly why his comparisons to other cases are utterly irrelevant. This case isn't like the others. It's uniquely heinous, and that specific detail will now almost certainly be the basis for a very, very long sentence.
Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret, because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you seem as punishable, Your Honor.
All right.
And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it two ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is, what's appropriate punishment for this type of case for
All
Mr.
right,
Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you?
The arguments are over. The defense made one last attempt at mitigation, pointing out that the defendant himself was allegedly a victim of grooming as a child. But now the final decision rests with the judge. She delivers a powerful monologue, explaining the immense difficulty of her task. She acknowledges that on the surface, this is the type of case that people automatically scream life in prison for. However, she emphasizes that her decision must be based on all the facts, not just public outrage. She speaks of her duty to protect the public, to consider the defendant's age, and to weigh the evidence presented, including his own acceptance of responsibility. The defendant, his parents, and the attorneys can do nothing but wait as she weighs a lifetime of consequences. The state asked for life. The defense pleaded for 20. The final number is coming now.
All right.
All right.
All right. Thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So
45 years. The judge has delivered her sentence, and it is a crushing blow to the defense. 45 years in the Texas Department of Criminal Justice. This is not a compromise. It's a sentence that lands far closer to the prosecution's request for life than the defense's plea for 20. The judge is sending an unmistakable message. While she didn't impose a life sentence, she has ensured that Christopher Davis will be an old man before he is even eligible for parole. She also imposed a no-contact order with the complainant and any minor plus lifetime sex offender registration. This sentence reflects the gravity of the crime she laid out moments before: the catfishing, the manipulation, the profound breach of trust. The legal battle is over. The defendant has learned his fate, but the hearing isn't finished. Now we will hear from those he victimized.
state, what are you requesting?
Do you want my request and my argument, or just my request? Right?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, state, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake. And
This is a truly remarkable and complex moment. Immediately after sentencing Christopher Davis to 45 years in prison, a term that will consume most of his remaining life, the judge offers him a moment of praise. She acknowledges his decision to enter an early plea and to take full responsibility without being wishy-washy. This is a fascinating insight into the judicial mind. The judge is capable of separating the horrific nature of the crime from the defendant's conduct within the legal process. In her view, his acceptance of guilt, while not absolving him, is a commendable act within the confines of the courtroom. It saved the victim the trauma of a trial and showed a flicker of accountability. It's a moment of humanity that doesn't lessen the punishment, but it does add a surprising layer of nuance right before we hear from the people whose lives he irrevocably damaged.
how they raised us, at some point, your actions are your own. All right. So I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intend to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet, the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injuries to a child causing death. And the very next day, this same prosecutor's office, same prosecutor,
I'm going to object to this
offered them 18 years.
All right. Okay. So here's the thing. Defense attorneys, you all know that sometimes people can be at the Bexar County Jail or at the prison. Sometimes there are people at the prison for murder. They get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So.
The victim impact statement is absolutely searing. This isn't just a story of sadness, it's a declaration of survival filled with pure, unadulterated rage. The victim makes it brutally clear, I still hate your guts and wish you the rest of your life in prison. She completely rejects any notion of forgiveness, stating, you might be able to convince other people, but you won't get it from me. She then lays out a devastating inventory of the damage he caused, PTSD, depression, paranoia, trust issues, and multiple suicide attempts. But in a moment of incredible strength, she also points out that his evil actions inadvertently freed her and her family from him, placing them in a safer environment. This statement is a powerful reminder that while the legal proceedings provide a sentence, the true life sentence of trauma is carried by the victim long after the gavel falls.
The argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right, so
For a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead.
The second impact statement from the defendant's ex-wife, Ashley, broadens the scope of his destructive behavior. She speaks of 16 years of lies, manipulation, and gaslighting so severe that it made her believe she was crazy. Her testimony paints a clear picture of a man who was not just a predator to one child, but a controlling and emotionally abusive partner who systematically isolated her and played mental games. This context is vital. It shows a pattern of behavior that extends beyond the specific crime he was sentenced for. Her statement culminates in a powerful moment of reclaiming her own strength, telling him his actions say more about his character than hers. She hopes he lives peacefully with his choices, because she and her children won't be losing sleep over you anymore. This is the sound of a family finally breaking free.
Of a 14-year-old, and this fellow gets 12 years, and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever that you choose to give him. So
Okay.
that's the only reason I'm offering that, Judge.
Right.
And again, back to I'm not trying to make you mad. I
No,
don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that it's any excuse for what happened, and he doesn't even really know if it went any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. this is the type of case where everybody will say automatically it's a life case. Right? But I go on facts, I go on what I read, I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We prove it, you get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come. Right? So sometimes when I consider what to sentence somebody to, I think about their age, I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Sure. All right, we can go off the record. Here's the thing I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right, so can you mute us, please? All right, you may proceed.
Do I start reading?
Yes.
Okay. Even after all you've done, after all of the activities you did and all the messed up things you did to our quote unquote family, I was able to fill myself with remorse, empathy, and sympathy for you. Now, don't twist it because I still hate your guts and wish you the rest of your life in prison. Also, don't be expecting forgiveness out of me. You might be able to convince other people, but you won't get it from me. You ruined a lot, but don't go raising your ego because you thought you ruined my entire life. You've only ruined things in it. You got away with it. Or you've also improved my life. You got me away from you and Ashley. You brutally taught me how not to be so naive. You got the rest of my family away from you and Ashley and into a safer place. But most importantly, you found a way to wind yourself in prison. Here's a small list of all the things you've done to me, starting with the bad. You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, plus 4 different attempts. Depression, anxiety, paranoia and trust issues, problems with talking about my feelings, nightmares constantly, fear of using any bathroom, gender questioning, panic attacks, caffeine addiction, slight smoking addictions, not being able to make friends easy due to trust issues, and problems with family members. Here's the list of good things you've done in my life. You put me into a position where I was being put with people who actually care for me enough to take Wyatt and I as their own children. That's it.
All right, thank you. Is there anyone else? All right, Ms. Davis?
Yes, Judge.
All right, you may proceed.
So I'm not sure where to start or the things to say to you, but this is where I'm going to start. Almost 16 years ago, when we got married, you said you would never hurt me or my daughter, who was only a couple months old at the time, or any kids in the future that we would have together. And I believed you. As our marriage went on, you ended up breaking that promise. You made me believe that I was crazy, and to the point to where I had to see doctors, therapists, and I didn't have friends anymore. I tried to help you be a better person, and it made you mad. I had no real warning about who you were. I'm glad I finally realized it with the help of some friends that I did make, and I made it out 7 years later. I made it out before things got so much worse than what they already were. Separated, divorced, went to court for our kids. You made people believe that I was doing things to our kids, and I wasn't. You played mental games with me and would verbally abuse me as well. After everything that you put me through, all the tears and the 7 years, you had everybody still believing that I was doing all of this. But eventually, you were caught because you did it. Sorry. I've been angry, yelled, screamed, cried over everything, and I blame myself for it, for not being able to protect our kids. You're not half the person I thought you were. But after all these years, I realized that your actions say more about your character than they do about me. I hope that life gives you everything that you deserve and you live peacefully with your choices that you've made, because our children and I won't be losing sleep over you anymore. You are where you belong. I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too
I'm gonna
quickly.
object to this.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so
Okay.
much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you.
Thank you.
All right.
This case ends not with a plea deal, but with a stark reckoning. Christopher Davis put his fate in the hands of the court, and the court delivered a severe verdict. The defense's pleas for mercy, citing childhood trauma and parental guilt, were powerfully eclipsed by the judge's reveal of the crime's true manipulative nature. An attempt to argue for a lighter sentence by comparing it to other cases was masterfully dismantled, proving that the unique, horrifying facts of this case put it in a category all its own. In the end, after hearing the raw and furious impact statements from his victims, the judge handed down a 45-year sentence, a decision that valued public protection and punishment far more than mitigation. While the defendant accepted responsibility, it was the voices of those he harmed that echoed loudest in the courtroom. What did you think of the judge's reasoning and the final 45-year sentence? Let us know your thoughts in the comments and subscribe for more in-depth courtroom analysis.